You're watching FJTN, the Federal Judicial Television Network.
Welcome to the Federal Judicial Center's program on the consumer aspects of the Bankruptcy, Abuse Prevention, and Consumer Protection Act of 2005. Today we'll be concentrating on those aspects of the new law that most affect consumer bankruptcy practice. We'll be assuming that by now you are familiar with the terms of the new law. Hopefully you've been to see the FJC overview, and many of you have been to many other programs and in fact have probably participated in those programs. Joining me here today are two consumer bankruptcy experts. Judge Eugene Wedoff from the Northern District of Illinois. Welcome, Gene.
Thanks.
And Judge William H. Brown from the Western District of Tennessee. Welcome, Bill. There's an outline to help you follow our presentation, and we've also referred to other manuscripts. Particularly helpful is Eugene Wedoff's manuscripts on consumer issues. We've also included the new suggested interim rules and the new interim official forms. There's also a summary of the suggested interim rules that was prepared by the reporter to the Advisory Committee on Bankruptcy Rules, Jeff Morris. The Bankruptcy Rules Committee and the Standing Rules Committee have approved suggested interim rules, and they've asked each local court to adopt those rules in their entirety without change. Additionally, the Judicial Conference has approved the interim forms as official forms. Recently, I had the opportunity of talking with Judge Tom Zilli, who's the chair of the Advisory Committee on Bankruptcy Rules, and I asked him about the suggested interim rules, and here's what he told me in his telephone interview.
The law was signed into effect on April 20th, and we had our first meeting of the Advisory Committee on April 21st, and we divided ourselves into really 6 subgroups to study the new law and determine what was necessary. We had done some preliminary work back in 2002 when a similar bill was pending. But we divided into consumer, business, cross-border, dealing with the Chapter 15 provisions, which are all new, the health care, appeals, and then a forms subcommittee. And these groups met several times, both in person and by telephone. And we have drafted proposed interim rules and proposed forms to implement the new law. Basically, what we tried to do was create rules that were necessary in order to implement the new law. We did not attempt to make any changes to existing national rules except were absolutely necessary to implement the law, with one exception. Rule 4002, dealing with the duties of a debtor, had gone through a national rules process. It was actually with the Supreme Court, and they were going to send it to Congress. It would have been effective at the end of this year. We pulled that rule from the Supreme Court, asked them to withdraw it, but we do now have in the interim rules package a Rule 4002 changes, which does 2 things. It implements changes by the new law, and it also incorporates some of the changes which had been published and we received comment too. So with the exception of Rule 4002, everything else is essential, we believe, to implementing the new law, nothing more.
What happens if the committee made a mistake or left something out? Is there a way to correct that?
Well, that's a good question, Tom. We are going to, when we send this out to the courts and when we put it up on the Administrative Office website, we're going to invite comments to our interim rules, and if we find something that needs a revision or a new rule that we haven't dealt with, we'll take whatever action is appropriate to advise the courts of that omission or correction. I want to emphasize, though, that these are interim, and we do anticipate going through the normal rulemaking process. What this means is that we're going to take the interim rules that we are going to submit, and we're going to study them. There are at least 2 or 3 rules we know of already that we're not submitting as part of the interim rule package, but we know for purposes of the national rules they will be necessary. We've even approved 2 such rules. But in any event, we'll go through that process. Next spring, we'll recommend to the Standing Committee and the Judicial Conference essentially the national rules that will go forward. We'll publish those a year from now, receive comments, hold public hearings, and ultimately a couple of years down the line from then, we'll have national rules in effect.
Now the forms, although they are interim forms, have been approved by the Judicial Conference, which means that they are binding pursuant to Rule 9009. The suggested rules, however, have to be adopted locally. Now, Rule 9029 provides that the district court judges, or by delegation, the bankruptcy judges, make the local bankruptcy rules in accordance with Civil Rule 83. Now, Civil Rule 83 requires that there be appropriate public notice and an opportunity for comment. Gene, do you think that notice and opportunity for public comment would be required here?
No, and I think there are really 2 reasons for that, Tom. The first is that there simply isn't time to do it. We've got to have these rules in place as of October 17 to deal with the cases that are filed that day. There isn't enough time to send out notice, receive comments, and then respond to them between now and October 17. Beyond that, the hope is that we're going to have uniform rules.
There'd be nothing to comment on.
Exactly.
Okay. All right. Well, let's talk for a minute about what the suggested interim rules and forms cover and don't cover. Is there a means test form?
Most certainly. A new Form 22 that'll be a separate one for each one of the chapters in which individuals can file.
Will there be a reaffirmation agreement form?
No. The Rules Committee decided that the statutory language was so specific on the forms that were required for reaffs that an official form would be redundant.
Well, how about a fee waiver form?
Yes. Individuals filing in forma pauperis will be required to use an official form.
Were there any changes to Rule 9011?
No. The committee decided not to issue a change to 9011 on an interim basis. That'll be taken up in the usual form.
Okay. What about maximum fees for petition preparers?
No. Although the committee would be allowed to recommend that, it has not been acted on immediately.
So that would be something that would be
would
down
go
the
through
road.
the regular 3-year rules-making process.
What about a deadline for filing complaints objecting to the dischargeability of debts in the Chapter 13 case?
Yes. That will be subject to the same 60-day requirement after the first day set for the 341 meeting that applies in Chapter 7.
Okay. Judge Brown has included a very helpful chart in the outline dealing with the changes to discharge and dischargeability. He's also written a very comprehensive article in the American Bankruptcy Law Journal, and let me just take a minute to recommend to you the American Bankruptcy Law Journal most recent volumes that have a number of articles dealing with the most important changes. And it's really a wonderful resource, and it's available now, and I hope you will take advantage of that. Gene and Bill, what are some of the discharge and dischargeability changes that most affect consumer bankruptcy practice? Gene?
Well, one that's certainly gotten a lot of coverage is a change in Section 523A2, the credit card dischargeability fraud exception to discharge. And what's happened here is that the presumption of fraudulent use of a credit card has really been expanded. Before, we had a 60-day period in which the use of a credit card might generate a fraud if it was used to purchase luxury goods or services or used to obtain a cash advance. The amount of the luxury goods and purchases that had to be obtained from any given creditor was $1,225. Same $1,225 for cash advance. So that's a fairly large amount in a fairly short time before the bankruptcy. What's happened under the new legislation is that the time period's been expanded. It's now 90 days for luxury goods and services, 70 days for cash advances, and the amount of money that has to be charged is reduced. It's now $500 for luxury goods and services, $750 for cash advances. So we've got a much broader presumptive period and smaller presumptive amounts. Now,
What's the effect of that?
Well, the effect is to make it more likely that debtors will want to settle dischargeability matters or enter into reaffirmation agreements to resolve them. But in terms of practical impact on a matter that's actually litigated, I don't know that it will have that much effect, because it's still going to be a question of whether the debtor's believed or not.
Gene, what about student loans? Any change there?
Yes. What's happened with student loans is that there used to be a limitation on the creditor who could claim non-dischargeability. The creditor had to be a government entity that had guaranteed or made the loan, or it had to be a nonprofit organization, likely the school that the debtor was attending. Well, that's been eliminated now as a limitation. Any creditor who has issued a qualified student loan, educational loan is defined by the Internal Revenue Code.
So that would be a bank if a bank
Certainly,
made the loan?
A bank that gave a loan that was limited to educational purposes would be covered by this, but the definition in the Internal Revenue Code is broad enough that it might even cover a cash advance from a credit card that was used exclusively for educational purposes.
What about relatives?
Relatives are excluded from the Internal Revenue Code's definition of a qualified education loan, and so they wouldn't be able to claim this non-dischargeability.
Now, what kind of institution is it that would qualify as an educational loan?
Well, the only limitations are institutions that give courses of a specified length and courses that either result in some kind of undergraduate or graduate degree or train someone for a recognized profession.
Is the bartending school?
I would expect that the bartending school would certainly consider its students to be professionals.
Okay. Bill, what about changes to 523A15?
A15 is a significant change, Tom, because you first have to tie it to the overall concept of what's called domestic support obligations that we'll talk about later. That term replaces the old alimony maintenance and support, but it includes that still. A15 now basically says that any debt that doesn't qualify under A5 as a domestic support obligation, but that is connected somehow to the marital dissolution or some order related to that, is accepted from discharge. The big example would be property settlement agreements and perhaps hold harmless agreements to other third-party creditors. The big change is really in the elimination of the defenses, what we used to call defenses under parts A and B of A15. They're now gone, so the debtor basically has no defense to this. The significant thing is that A15 is still dischargeable in Chapter 13, but not dischargeable in the other chapters for individuals.
Okay, you mentioned Chapter 13. Will it make a difference whether it's an obligation for support or whether it's an other obligation under a divorce decree or something?
It really could. In Chapter 13, the 523A5 obligation will be a priority non-dischargeable obligation, whereas the A15 type debt, the property settlement debt, would be a non-priority and perhaps dischargeable in the Chapter 13. So it can make a big difference in how they're treated in the plan.
Mm-hmm.
It makes a big difference in the way a debtor wants the debt treated, depending on whether the debtor's in Chapter 7 or in Chapter 13.
That's correct.
In a Chapter 7 case, the debtor wants to get as much debt counted as 523A5 as possible so that any assets in the estate are used to pay that debt, and the debtor emerges from Chapter 7 with a smaller non-dischargeable debt. In Chapter 13, the debtor wants to get as much of it counted as A15 as possible so that the debt will be dischargeable and can be paid on a non-priority basis.
Okay, what about 523C with respect to A15?
Another significant change, and we will definitely see this in the practice that we've been accustomed to. A15 has been one of those debts that fell under Part C, that is, those debts that the bankruptcy court had exclusive jurisdiction over. in contrast to A5, where the state courts had concurrent jurisdiction. Now that's changed where A15, like A5, concurrent jurisdiction with the state courts, no longer the exclusive jurisdiction. Complaints may be filed at any time, even reopening the case if necessary. So I think from a practice standpoint, we'll see more opportunity for parties to move for relief from the stay, go to the state court to resolve a divorce that might be pending or other matters related to it, and the state court would have concurrent jurisdiction to decide both A5 and A15.
Do you think most of these will be determined by the state court?
You know, of course, it will depend on each locality whether the state court wants to act like a bankruptcy court and make those decisions, but clearly the opportunity is there, and there may be certainly more opportunity for us as bankruptcy judges to abstain from those questions.
Okay. Gene, we mentioned that A15 is no longer is non-dischargeable under, or is dischargeable under Chapter 13. Are there other debts that are non-dischargeable under 13?
Yes. One of the curious things is the way A6 debts have been treated under the new law. A6 remains covered by the super discharge, but Section 1328 has its own exception for debts that are caused by willful or malicious injury if those debts have been the subject of a judgment in a civil action. So we don't have quite a correlation between A6, which is only non-dischargeable in Chapter 7, and this new provision in 1328 that covers some of the debts that seem to be addressed in A6.
Does that mean that a Geiger-type debt based on negligence would not be dischargeable?
Well, for sure, the Geiger debt would not be dischargeable if it was the subject of a civil judgment that was obtained before the bankruptcy, because the definition of willful or malicious is broader than the definition of willful and malicious in A6. On the other hand, the need for a civil judgment may be a limitation on the use of 1328 to render a debt like that non-dischargeable.
Unless you take the position that the bankruptcy court judgment of dischargeability or non-dischargeability would be such a judgment.
Yes, and the courts of appeal seem to be split on the question of whether the bankruptcy court can actually enter a money judgment in connection with a dischargeability determination.
Well, what about the bar dates in Chapter 13 then?
Well, as I mentioned earlier, there is the same 60-day bar date for any claim that's covered by Section 523C. So for A2 and A4 complaints in Chapter 13, they're going to have to be brought within that time frame. A6 is not covered by Chapter 13's exception from discharge, and this special 1328 is not something that falls within 523C. So this special limitation of the 13 discharge for certain personal injury actions can be asserted in state court. There's no deadline for it being raised in Chapter 13. For the A2 and A4 matters that do have a deadline, though, 60 days.
Well, what happens if there's a conversion? For example, what I'm thinking about is what happens if a debtor proposes a plan that will pay 100 cents on the dollar to creditors. There's a creditor that has a claim that would be non-dischargeable in Chapter 7. They've got the 60-day bar date. They let the 60-day bar date go because the plan's going to pay them 100 cents on the dollar. What happens when the case is converted to Chapter 7?
They're going to lose that claim if they haven't asked for an extension of time to file the complaint. And by the way, Tom, the problem you mentioned also arises if the debtor seeks to modify the plan and have a much lower payout to unsecured creditors. If that creditor hasn't asked for an extension of time beyond that 60-day period to file a complaint and fails to file a complaint within the 60-day period, the right to file a complaint is going to be lost.
Well, when you have these objections filed, objections to the dischargeability of a debt filed in Chapter 13, when are they tried? Do you try them at the beginning of the case? Do you wait till the case is over, or at the end of the case, or when are they tried?
Well, that's going to be in the discretion of the judge, just the way it is now. Many of us, if we have a joint 523, 727 complaint, will try the 727 first and hold off on the 523 because it may never come up. The same sort of thing could happen in a 13, where a complaint's filed but the debtor's behind in payments and the judge anticipates that the Chapter 13 case may be dismissed for non-payment. No particular reason to rush into a dischargeability trial. So it's going to be the judge's discretion.
Bill, any changes to the 727 discharge?
There are, and one that was talked about in the last program, of course, is just simply the change from between 6 years and 8 years. In other words, you can't get another Chapter 7 discharge for 8 years now. There is also, and we won't go into the details of this, we're touched on in the prior program, that in Chapter 13 there are new time limits between successive Chapter 13 discharges. There also is an overlay in all of the chapters for individual debtors that to get a discharge, they must complete a debtor education course, a financial management education course. So that's sort of a prerequisite to getting the discharge, and the debtor's going to have to certify or file some evidence that they did that.
Okay, well, let me back up a minute, though. If a Chapter 13 debtor can't get a discharge as easily as they used to be able, does this mean they're not going to be able to file Chapter 13?
No, it does not necessarily, because those prohibitions that might exist against a successive 13 discharge would not necessarily prevent the debtor from filing again, assuming the debtor files in good faith and all of those types of things, and there's not another basis to dismiss it. If the debtor is simply seeking, for example, to cure the home mortgage arrearage, and the debtor doesn't care about getting an ultimate discharge, and the debtor meets that goal, the case simply gets dismissed after curing. No discharge is granted, so that in itself could still be done.
So you could have a confirmed plan where the end does not mean that there'll be a discharge.
Absolutely.
In that case. Gene, what about 522Q, then the delaying of the discharge? I know there's been a lot of concern about that.
Yeah, 522Q is a new basis for objecting to a large homestead exemption. If the debtor's claiming a homestead exemption of more than $125,000, that discharge could be limited to $125,000 if the debtor's been convicted of a felony that shows an abuse of the bankruptcy code, or if the debtor has committed securities law violations or a personal injury that a serious nature or wrongful death. These things could result in a limitation of the homestead exemption to $125,000. Now, what the drafters apparently recognized is that the conviction of a felony or the finding that the debtors violated the securities laws or caused a serious injury or death may not be determined while the case is pending, and while an objection to discharge could be asserted in the ordinary time period that we have, 30 days after the conclusion of the meeting of creditors. So the rules are going to provide that this 522 objection can be made anytime prior to case closing. Moreover, the drafters have provided in each of the chapters involving individuals that the discharge should be delayed if there is pending a proceeding that might give rise to a 522Q objection. The Rules Committee has looked at that set of delaying of discharge provisions, such as 727A12, and concluded that there's only going to be a hearing on that question if it's raised to the court. So the clerk's office is not going to have to be searching through the files to determine whether the debtors claimed a large enough homestead exemption and whether there might be a proceeding like this pending. If notice is given of a need for such a hearing, the court will look into the question. Otherwise, a discharge would be issued in the ordinary course.
So I'm not going to need to have a discharge hearing in every case just to see if 522Q applies.
That is absolutely the intent of the Rules Committee.
Okay, well, last time we talked about valuation, but because it's so central to the bankruptcy process, we thought we would mention it again. Bill, Section 527A2B says that a debt relief agency must advise the debtor that replacement value, as defined in Section 506, must be stated in those documents when requested. What do you make out of that?
You know, there really could be a range of views. One view could be simply that when requested means that if the debtor's filling out a schedule or any pleading that calls for a line to put in a value, that the debtor must use the replacement value. And we're talking about consumer debtors again, individual debtors.
So unless the form actually said we request replacement value, you put in something else. That's one interpretation.
That's one interpretation. Another interpretation certainly might be that, well, only if the law, of course, some specific statute requires it. Well, that's where we run into an interesting question, because there's a difference in the language of 506A2 that was added. 506A1 was not amended. The normal bifurcation or determining the value of a secured claim. It's A2 that was added to say that for 7 and 13 individual debtors, personal property values are replacement value. And in fact, if it's for household purposes or personal purposes, it goes on to say that means retail. Now, the problem is that's not the same language we're accustomed to in other sections of the code that were not amended.
Okay, well, let's take a few examples. What about, what value do you use when we're talking about redemption under 722?
It seems to me for redemption, since it's Chapter 7 and we can only redeem personal property that's exempt or has been abandoned, that we are now having to go back to 506A2 and say that debtor surely must have to use replacement value.
Okay.
And retail.
And that means retail for that context, I think.
All right, now what about the value for determining exemptions?
That's very interesting because 522A has a definition of value for exemption purposes that was not amended. And that value uses the term fair market value for the property of the estate that's claimed to be exempt. All right, what does that mean? Well, one view again would be that for 7 and 13 individual debtors, you must have to overlay 506A2 on that exempt value, meaning that maybe Congress has defined fair market value, which can mean different things to different people, has defined it as meaning replacement/retail for those debtors.
And perhaps other support for that argument might be 527C3 that says...
That's correct. That says the debtor must be told and advised that that's the value to use.
Now, the counter argument would be that the courts had largely interpreted fair market value in the context of exemptions to mean liquidation value, and Congress didn't change 522's definition of fair market value, so you could say that they intended that to carry over. Which view prevails will remain to be seen.
And in fact, they amended 522F and used the term fair market value in at least 2 situations. What about the value with respect to cramdown in Chapter 13?
That's also interesting because we're now going to have potentially a different standard for Chapter 13 cramdowns as opposed to 11s and 12s, whereas in 11 and 12 you still could use 506A1 to bifurcate a secured claim. In Chapter 13, for cramdown purposes, it looks like you're going to have to use replacement value. And of course, if it's one of those special categories in Chapter 13, a car purchased within 910 days or other personal property acquired by the debtor for personal use within a year, they cannot strip down the value. So it would seem that for cramdown in 13, you're talking about replacement again / retail.
What about interest rates?
Interest rates is really an interesting question because obviously Till was not legislatively overruled. And so even though the debtor in 13 can't strip down the value of a car, for example, could not the debtor still perhaps propose a plan to alter the interest rate or to perhaps alter the times, the number of months of payout?
Well, you know, you have to look at the way in which this anti-cramdown provision was inserted into Section 1325. It's a limitation of what can be done in 1325A5, but I think it retains the idea that it's a secured claim and that there would still have to be present value of that secured claim paid over the course of the plan. So my guess is that some interest rate is still required, but Till tells us to look at adjusting the risk to the creditor, adjusting the interest rate, the prime rate, based on the risk to the creditor, and if the creditor is being paid the full amount of the secured claim in periodic payments, it might be that the interest rate could be lower than it otherwise would
So
be.
instead of taking the rate and adding for the risk factor, you would reduce for the risk factor.
I think you well might.
Arguably so, because in fact, some of those creditors are not, in fact, they may be oversecured, in fact. So where's the risk would be the argument.
Okay, Bill, what value do we use when we're looking at the liquidation test in
Well, you know,
Chapter
still
13?
in Chapter 13, as in the other chapters, when you're talking about the best interest of creditors test or comparing what the creditors would receive in a Chapter 7 case, you're now back to talking about liquidation value, and those parts of the code were not changed.
Well, Gene, last time you did, I thought, a masterful job of explaining which law applies for purposes of claiming the homestead, and we won't go over that again. But there were other changes to the exemption law and other changes to what is property of the estate.
Yeah, and there are three that I'd like to talk about. But obviously, taking property out of the estate is just as good as exempting it, maybe even better. And there are a couple of areas where the code does that. There is a new section 541B5 and B6 that exclude education individual retirement accounts or state tuition programs that are like these educational accounts. And they are very generous in the exclusion from the estate. Contributions that were made within a year of bankruptcy are still part of the estate, but between 1 year and 2 years prior to the bankruptcy, up to $5,000 can be put in each child or grandchild's educational account. Beyond 2 years prior to the bankruptcy, there's no limit. Whatever the IRS would allow to be deducted can be excluded from the estate.
And that would be pretty generous, I
Very
take it.
generous, yes. Section 541B7 excludes contributions to benefit plans, deferred compensation plans, tax-deferred annuities, state-regulated health insurance plans. No limit on the amount that can be excluded from the estate there. And then beyond these exclusions from the estate, very generous exemptions under 522B3 and D12 for all sorts of retirement accounts. Now, IRAs are subject to a separate limitation, but it's not much of a limitation. 522N provides that IRAs are capped at $1 million unless the debtor needs more.
Right, and so you might have a hearing. We can expect some hearings in those kind of cases where the debtor is saying the interest of justice, the language demands that I get more than $1 million.
But it's pretty hard to get $1 million in an IRA at the level that the IRS allows you to contribute. So I don't think we'll have too many of those hearings. Now that was one. The second point I wanted to cover is a limiting definition of household goods. Now, what we're talking about here are non-purchase money security interests that can be avoided if they impair the debtor's exemption. So the debtor goes into the local loan store, they ask, what kind of collateral do you have? And the debtor lists all the things that are in the debtor's house and the loan's given. Okay, non-purchase money security interest. Debtor wants to avoid that. Well, the debtor can avoid it if it impairs an exemption in, among other things, household goods. And now there's a limitation of the definition of household goods that can be used for that purpose. And it's a strange one. It includes one personal computer, one VCR, one television, no DVD player, all of these things to fall within an overall $500 limitation on electronic entertainment equipment. It excludes all jewelry except wedding rings that are worth more than $500, and it in general is very tightly restricted. The problem is that this is only one term in a list of terms that can be used to avoid non-purchase money security interests. And other terms in that list are household furnishings and jewelry. So since jewelry is separately exemptable without a limit, it doesn't appear that the definition of household goods will have much of an impact. The biggest impact here is going to be to exclude motor vehicles. Some courts had held that motor vehicles could be considered household goods, and so non-purchase money security interests in motor vehicles could be avoided under this section. That won't be possible anymore. Okay, the third point that I wanted to cover is a series of limitations on the homestead exemption that go beyond how long you have to live in a state before you can claim that state's homestead exemption. That we talked about last time. There's a new 522O that says that any additions to the value of a homestead that the debtor makes in the 10 years before the bankruptcy are going to be excluded from the homestead exemption if the debtor made the addition to the homestead with actual intent to hinder, delay, or defraud creditors. So that's a 10-year reach back, and there's no cap on what can be taken away from the debtor under that provision. A new 522P is similar, but it has no requirement of actual intent. So any addition to the homestead that's made under this provision can be taken away, but there is a limitation. It's only above $125,000, and another limitation is that the debtor can continue to hold a homestead from the same state transferred into a new homestead and not be subject to this $125,000 cap. Now both 522O, the 10-year reach back, and 522P, this $125,000 reach back, went into effect immediately. Another thing I should say about 522P is that its reach back is 1,215 days, or 3 years, 4 months.
So we've already had some cases under this new law that went into effect on April 20th.
Yes, we have, and the decision you're referring to is In re McNabb, issued by Judge Randy Haynes, and what McNabb holds is that the language of 522P, this 1,215-day reach back without regard to intent, only applies in non-opt-out states. The decision focuses on the language of 522P, which says that the debtor's increasing this homestead exemption by virtue of making the election that's called for in Section 522. Well, the election, Judge Haynes says, is between federal law exemptions and state law exemptions.
So this is a pretty plain meaning reading.
A strict plain meaning that the election is the critical word in the statute, and since there's no election between federal and state exemption regimes in an opt-out state, there's no application of Section 522P. Now, it could be argued that the election is simply to assert an exemption. You never have to assert an exemption, you elect an exemption. Some judges might take that view of the statute as well, but certainly Judge Haynes recognized that there could be some tension between the underlying intent here and the impact of the plain meaning rule.
Right. Well, that case didn't involve a constitutional challenge, but we were wondering the other day if there might be some aspects of the new law that would be subject to constitutional challenge. And so we asked our expert, Erwin Chemerinsky, what he thought. Here's what he had to say.
I don't expect any constitutional challenges to the entire Act, but I do think that there will be constitutional objections to specific provisions of the Act. Let me give you several examples of provisions where I think you can expect to see constitutional arguments. One is a provision that says that attorneys cannot advise their clients to take on additional debt, even when it's lawful for them to do so. Under this provision, a lawyer could not advise a client to get a mortgage, even be completely legal. I think there's going to be a strong argument that this violates the First Amendment rights of lawyers and clients. A second provision that's likely to be challenged is one that concerns advertising by lawyers who are engaged in representing clients. They're going to be required in any ad to say they're a, quote, debt relief agency. The way the provision is written, it would seemingly even require attorneys for creditors to call themselves debt relief agencies. And I think you'll see an argument that this is compulsory speech that violates the First Amendment. A third constitutional argument will be that all of the regulation of lawyers in the new Act violates the 10th Amendment. The claim is going to be that it's a traditional state function to regulate lawyers, and if the federal government engaged in this process is objectionable. On the other hand, the reality is federal courts have long regulated attorney practice. I don't know if it's any different if it's Congress. A fourth constitutional issue is whether in involuntary Chapter 11 proceedings there's a violation of the 13th Amendment, whether it's impermissible peonage. The way in which the Act is written, it says that a debtor can be required to pay off debts over a 5-year period. Is this obligation, in essence, to work to pay off debts peonage? Is it involuntary servitude? A fifth set of constitutional objections will concern the means test. Undoubtedly, one of the most important parts of this reform is the means test. But the way it's calculated varies across the country. Does this violate the requirement for uniform rules for bankruptcy? Does the difference in different parts of the country deny equal protection? I'm sure courts will see these arguments made. One other constitutional issue concerns privacy. Under the terms of the Act, creditors have full access to records with regard to debtors' income and with regard to other aspects of the debtor's financial condition. Certainly some debtors are going to argue this easy access to information violates privacy. Regulations are being drafted here, but nonetheless I think you're going to see in this area, like the others, constitutional challenges being brought.
Now, Gene, do you have any comments?
Well, I certainly do. I have a concern that the sort that Professor Chemerinsky raised. The question of the homestead exemption may also be a subject of constitutional challenges, since some states feel very strongly about that, and they certainly have it in their own constitutions. Last time we talked about 522Q, we mentioned it earlier today, this absolute $125,000 homestead cap. I just wanted to mention that that has the same election language in it as 522P, and so would be subject to the same McNabb analysis, limiting it to non-opt-out states. And that's in contrast to 522O, which has no election language, and that's one of the reasons why the plain meaning approach appeared necessary to Judge Haynes.
Okay, Bill, last time we talked about avoiding powers. We didn't talk about all of them. I know there are some other ones that are significant. What are they?
There are several that we will see in consumer cases, some, of course, that you don't normally see in consumer cases. But one thing, for example, the venue statute, 28 U.S.C. Section 1409, has been amended to provide that when the trustee is suing on a consumer debt, for avoidance of a consumer debt for less than $15,000, that suit must be brought in the district where the defendant resides. Also, there are changes to the ordinary course of business defense, which of course typically would come up in the business case but could come up in a consumer case. Now the defendant has a much easier path by using not both the subjective and objective test, but may use either to prove that defense. The trustee may also now be prevented from bringing a fraudulent, a preference recovery action if it can be shown that that was made in payment of under a repayment plan that the debtor had entered into based upon one of these nonprofit budget credit counseling agencies where they set up a repayment plan outside of bankruptcy, and if payments were actually made that would otherwise be preferential, that's not avoidable. Just like payments made to a domestic support creditor are not avoidable under the preference law. That's probably redundant because under 547B, with the change in the priority for those creditors that we'll touch on in a moment, the trustee would never be able to show that that domestic support creditor received more than it would have received in a Chapter 7 case. And finally, I might mention that self-settled trust we may see in some consumer cases where the debtor sets up and pays money into a self-settled trust. The reach-back period becomes 10 years, and it's necessary to show the debtor's actual fraudulent intent, but it's fraudulent intent as to creditors existing at the time the trust was funded or coming into existence later. So that's going to be some interesting proof. If the debtor, for example, funded a self-settled trust, didn't really have a significant creditor then, but a year later had one.
My hypothetical for you here, Bill, is the doctor who cancels his malpractice insurance and then puts his assets into the self-settled trust. Is that doctor covered or not?
You know, and of course the proof is to show that the debtor had a fraudulent intent to hinder, delay, and defraud creditors. And of course the debtor's going to say, I had no such intent.
No, I couldn't afford my malpractice insurance.
That's right, exactly right. Interesting proof.
Gene, last time you predicted that there would be no suggested interim rule dealing with 9011. As you told us earlier, you were right about that. But there are some certification requirements under 707B.
There are, and they're without an enforcement mechanism. We've got 707B4 with a couple of different, in C and D, a couple of different certification requirements. They apply to the attorney who signs a petition. So it looks to me as though any attorney who signs a petition in Chapter 7 may be liable for these statutory certification requirements, with the requirement enforced by the court and the court's discretion under Section 105. Now the certification is that there's been an investigation, an inquiry, that there is no abuse of Chapter 7 by the petition, and that the schedules reflect nothing that the attorney's inquiry has found to be inaccurate. So there are significant new certifications, but again, the penalty is going to be one that's up to the discretion of the court. No guidance from the statute.
Probably under 105.
Under 105, and probably looking to 9011 for guidance, because
is it a 100% certification by the attorney though, or a reasonableness inquiry that the attorney must make?
Well, reasonable inquiry, but there's an absolute certification of no violation of the provisions of 707B1. So it'll be interesting to see how that plays out.
Gene, last time we mentioned briefly debt relief agencies. What are some of the liabilities that a debt relief agency has?
Well, they're substantial. Debt relief agencies, and let me tell you, debt relief agency is defined in a very broad way. A debt relief agency is anyone who provides advice to a consumer debtor, someone whose debts are primarily consumer debts and who has no more than $150,000 in non-exempt assets. Any bankruptcy advice to that person for compensation is going to render the provider of the advice a debt relief agency. So potentially this could even be a creditor who gives advice to the debtor. There's an exception if they're talking about the debt that's owed from that creditor to that debtor. But if the creditor gives advice to the debtor about how to handle some other debt, could be a debt relief agency. It could be that a lawyer who consults with that consumer debtor about a claim that the consumer debtor has in someone else's bankruptcy could be a debt relief agency. So if the consumer debtor is employed by a company that goes bankrupt and talks to an attorney about how to file a proof of claim in the employer's bankruptcy, looks like a debt relief agency
So this
relationship.
definition's not just limited to debtors' attorneys. It could be a creditor's attorney, and it could even be a creditor.
It certainly could be. So that's one thing to keep in mind. Now, as far as the liabilities, well, there are a lot of requirements that have to be complied with. There have to be disclosures that are made. There has to be a retention agreement entered into. There has to be compliance with all of the terms of that retention agreement. Any services that are represented to be given must be given. There have to be compliances with all of the requirements of the bankruptcy code and the rules. Any failure to comply with those requirements that leads to a dismissal of the debtor's case, actionable. So a host of requirements. A requirement that any advertising contain a legend, any advertising of general relief bankruptcy services, has to contain a legend saying we are a debt relief agency. We help people obtain bankruptcy relief under the bankruptcy code, which is a remarkable proposition, as Professor Chemerinsky indicated. So lots and lots of requirements.
Okay, what about the court's role in responding to complaints about attorneys and in disciplining members of the bar?
Well, there are two separate provisions in Section 526. One deals with causes of action that the debtor, him or herself, might assert. And there's no specification of what court would hear that. So presumably that would be in the bankruptcy court. They'd be handled the way Section 329 hearings are handled now for a refund of fees that the debtor paid. Only now it's actual damages and potential injunctive relief, as well as simple refund of the fees that were paid. Beyond that, there's a provision in Section 526 allowing a state attorney general, highest law enforcement officer, or any agency with a similar function to bring an action to enforce the provisions of the debt relief regulations. And that action is specified by the statute to be one over which federal district courts have concurrent jurisdiction with state courts. So it may be that there's intended to be some restriction on the ability of the district court to refer such a matter to the bankruptcy court, though that's an open question.
Well, if you were a district judge, how would you rule on that?
I would find that it's a referable matter, but we'll see what happens.
Okay, what about petition preparers? Any regulations there?
Yes, there's a new Section 110 that's much broader than the old one, and it imposes new restrictions on petition preparers. As you mentioned earlier, Tom, a petition preparer is now going to be potentially subject to a fee structure established by the Rules Committee and the Judicial Conference. They're required to give a long list of disclosures to a debtor who's serviced by the petition preparer, including a list of all the legal advice that cannot be given by the petition preparer. That's the major points. And there's an issue that had come up about whether an attorney could be a petition preparer. I think the answer to that is no, because among the disclosures that the petition preparer has to give to the debtor is one that says, I am not an attorney. So I think being an attorney would contradict that certification.
Okay, Bill, you used the term earlier, domestic support obligation. What's that and what's its significance?
It is a new term that's used really across the board. Throughout the code, we'll see it quite often. It's defined in Section 101, 14A. It includes the old alimony maintenance and support, but it's much broader than that. It includes both pre- and post-bankruptcy domestic obligations. So It's a term that also includes obligations not simply to the recipient spouse or child of the debtor, but to government entities that may have had a claim on their own, not just simply an assigned claim, but their own claim that would fall under that category. So we see it, as we've already pointed out, in A5, 523A5 and A15. We see it also in other sections of the code, including, of course, the priority section, 507A1. Now domestic support obligations that fall within that definition rise to the first priority. Now 507A1 actually sets up 3 tiers. If the trustee administers assets that are for the benefit of those kinds of creditors, the trustee gets a super priority in essence. Then the domestic support creditor, recipient spouse or child, and then if there should be sufficient assets after that, government entities that have their own domestic support obligation claim would get paid on the 3rd level, but they're all in the first priority scheme of things. As we've already mentioned, 523C has a change dealing with 523A15, but moreover, in the exemption statute, 522C is amended to attempt to really preempt state law, because it says, notwithstanding any non-bankruptcy law, exempt property remains liable for domestic support obligation debts. So if you have a 523A5 type debt, that debt will still be able to pursue, that creditor pursue an exempt asset, if in fact that's what Congress was attempting to do and may have accomplished it. In the preference area, I've already mentioned that the trustee can't avoid a payment, preferential payment to a domestic support creditor.
Bill, can I back up for just a second? On that question of changing the exemptability with regard to domestic support obligations, does this mean that a trustee could sell an exempt homestead in order to pay a domestic support obligation?
You know, it may be a logical conclusion that certainly the trustee would argue that there are assets here that otherwise would be exempt, but because of the change in C, 522C, that asset is still liable for the debt, and consequently I, as the trustee, have an obligation to try to sell it and to pay the domestic support creditor, and if there's anything left, pay the debtor back the exempt portion of it. And the reason that logically may flow is if you look at the new duties of trustees, the trustees in all chapters have very defined duties to domestic support creditors, including advising them about an address and an office in each state where they might be able to get support assistance, to tell them the debtor's address. If the debtor moves, the trustee has to tell the creditor that, and to advise the creditor of any reaffirmations or certain non-dischargeable debts in the bankruptcy, not the domestic support non-dischargeable, but other types of non-dischargeable debts. The purpose is obviously, a whole scheme is to prefer these creditors. So it would be a logical argument that I would make as a trustee that yes, I can sell that exempt asset.
And you know, trustees do the very sort of thing we're talking about here in conjunction with property that's held in tenancy by the entireties.
That's correct.
Joint debts of both the husband and wife are not susceptible to the exemption of tenancy by the entireties. So a trustee could sell property held in tenancy by the entireties, pay off the holder of the joint debt, and pay the balance to the debtor. And we'd be talking about a similar sort of thing here.
A simple analogy.
Are there consequences to not paying current support obligations?
There are. I mean, the consequences both in potential dismissal of the case for that reason and not being able to get a discharge, because in all the chapters, including the reorganization chapters for individual debtors that have these types of debts, they can't get a discharge until they certify they're current in these support payments. There is one possibility that in a Chapter 13, for example, the debtor might pay a government entity that has its claim for domestic support obligation less than 100%. But only if they're funding the plan for 5 years and putting all of their disposable income. In other words, they're paying all they possibly can to other creditors, then they might be able to pay less to a government entity that has that claim.
But the balance would still be a non-dischargeable debt.
That's correct. That's correct.
How does this affect disposable income?
It does affect it, because in Chapter 13 specifically, disposable income does not include what the debtor's having to pay for current or ongoing domestic support obligations.
Okay, it seems to me in a lot of these cases we're going to see more and more pro se debtors. I mean, I've heard that comment made, but it makes a lot of sense to me that that's what we're going to see. Hiring a lawyer is going to be so much more expensive. Attorneys have the obligation to tell debtors that they can go it alone. And actually, many bankruptcy practitioners may get out of the business of filing consumer bankruptcy cases. And another thing I'm worried about is maybe having partial pro se debtors. In other words, the fees have gotten so high that attorneys, rather than increasing their fees, may be decreasing the services that they provide. And I think this is something that we as bankruptcy judges really need to think about, and how much we're going to let the attorneys get away with in not representing their clients.
Well, you know, partial representation may actually be an advantage to the bankruptcy system. If the choice is between pro se or partial representation by an attorney, we may be better off with the partial representation. Remember, as I see it, an attorney can't be a petition preparer. The only way that an attorney escapes liability is by actually being retained as the debtor's attorney. Well, if the attorney can't be retained simply to file a petition, can't unbundle the services to that limited extent, then the attorney has to refuse representation altogether, and we have pro ses from the beginning. It may be that the bankruptcy system's better off having an attorney able to prepare the petition, perhaps appear at the 341 meeting, but not have any further obligations to the debtor. And that's something that, as you say, Tom, courts are going to have to consider and come to their own judgments as to what the best answer is.
Right. I think we're also going to see more petition preparers, and that actually may be a good thing if the alternative is that you've got the debtor coming in with absolutely no help at all. And I think courts are going to have to balance what kind of help we give to the pro se debtors. If we give too much help to them, they're not going to need an attorney. They'll just be coming in, paying their fee, and we'll help them out. On the other hand, if we don't provide enough help, then the case always gets off-centered, and the whole system suffers as a result of that. Gene, you mentioned that there's going to be an informa pauperis form, a fee waiver form. How's that going to work?
Well, you know, it's funny, that really ties into what you were saying before. We could have a debtor now who doesn't pay any filing fee at all, gives us some documents that are very difficult to deal with and takes up a great deal of time of the entire bankruptcy administrative process. But to answer your question, yes, the statute now provides that any debtor who, one, earns less than 150% of the official poverty level, and two, is unable to pay a filing fee in installments, may obtain a waiver of the filing fee from the court. And the Rules Committee has proposed a form that's been adopted by the Judicial Conference to enforce that new provision in the law. The form is going to direct the debtor to list the applicable income the debtor makes for purposes of calculating their being under the 150% of the poverty level. And then it's going to have information about their expenses, so a court can determine whether they're really able to pay a fee in installments. Unfortunately, the information required for this form is different, both from the information required by Schedules I and J and the information required by the means test form. So a debtor who wants a fee waiver is going to have to fill out 3 different forms, all dealing with income and expenses. The official form for the order responding to the IFP waiver request allows a court either to grant the request, waiving the filing fee, or order that the debtor pay the fee in a specified installment, eliminating the need for the debtor whose IFP request has been denied to come back with a separate request to pay the fee in installments.
Let me ask, is it contemplated that I might waive part of the fees but require the debtor to pay half the fee, for example, or is my alternative you waive the fee or installments?
The form has the all or nothing approach, and I think that's probably what the statute implies.
Okay. What will be some of the consequences of not paying the filing fees if we grant a lot of these informa pauperis requests?
Well, without being flippant, we could bankrupt the federal judiciary. So much of the funding that the judiciary operates on is obtained through filing fees, and obviously the vast majority of bankruptcy cases are consumer cases. So if we routinely granted all requests for waiver of fees, we could have a massive impact on the budget of the judiciary. Beyond that, and in the context of a specific case, it's the filing fee from which the trustee's fee is paid. And if there is no filing fee, how a trustee is going to be paid for handling a no-asset Chapter 7 case is a really good question.
Yeah, I guess the answer to that is that the trustee doesn't get paid.
Well, that seems to be the answer right now because there's no funding mechanism to allow the payment.
Okay, Gene, let's talk about two Chapter 13 case management issues. The first, what are the consequences of the Section 1324B limitation on having the confirmation hearing 20 to 45 days after the 341 meeting?
It's going to require a number of courts to change their Chapter 13 procedures. I know that now many courts have a confirmation hearing on the same day as the 341. The trustee examines the debtor, approves the plan, and if there's no objection, the case simply goes to confirmation. Other courts wait until the expiration of the general claims bar date, 90 days after the first meeting, to determine confirmation. And both the short date and the long date are outside this range that the statute now specifies, 20 to 45 days. There's a possibility under the statute for reducing the time between the 341 and the confirmation hearing if there's no objection. But to have a meaningful opportunity to object, I would think you might have to wait until at least the 341 meeting itself to suggest that there be an earlier date. Other courts may think that it's possible to put that notice in the 341 notice and tell creditors before the 341 meeting that if they want a longer time before confirmation, they'll have to ask for it. But I think there'd be some tension in that practice between that and the statutory language. There's no provision in the statute for going beyond the 45 days after the 341. So it would appear to me that the only way to do that would be to continue the 341 meeting, since this talks about the conclusion of the 341, I believe.
One issue bankruptcy judges have been talking a lot about is how do you handle the pre-confirmation direct payments for adequate protection in a Chapter 13 case?
Well, let me say first, Tom, I think it's something that has to be handled. Fortunately, this provision only applies unless otherwise ordered by the court. And if there is no contrary court order, it's a highly problematic set of provisions. What the debtor is required to do is to make a direct payment of adequate protection in an amount that's not specified by the statute to every creditor who's secured by the debtor's personal property, and to make a direct payment to every creditor who holds a personal property lease that the debtor is enjoying. Those payments made directly to the creditor are to be deducted from the pre-confirmation plan payment that would otherwise be made to the Chapter 13 trustee. The balance is to be sent to the trustee, together with proof that the direct payment has been made to each of the affected creditors. For a debtor who's had sufficient difficulty dealing with their finances to wind up in Chapter 13 in the first place, this is an extraordinary set of requirements. But it can't.
Do you have a suggestion?
I do. We'll show on the screen a URL that'll connect to the FJC's website and show a proposed standing order that we've adopted in the Northern District of Illinois. That standing order, instead of directing the debtor to make individual payments to specific creditors pre-confirmation, tells the debtor to make the same payments before and after confirmation to the standing trustee, and then tells the standing trustee to make any payments from pre-confirmation amounts received from the debtor that would go to these individual creditors or lessors under the plan. So the intent of the statute, we believe, is met. The pre-confirmation payments are made. If the creditor feels it's not an appropriate amount under the plan, they can come in and argue about that, but there is not the difficult accounting and bookkeeping work required of the debtor.
Okay. Gene, last time we discussed the means test at some length. I know that every time I read Section 707B, I find something else, and it seems like there's always something more to say on it. Do you have anything more to say on it?
Well, a little bit more. And I will say the Rules Committee and the working group that I've served on has the same experience you do. Every time we look at this, we see something else. One of the more recent things that we saw was a need to change our original draft of the means test form to deal differently with self-employment income and rental income. Our original drafts had called for gross receipts to be counted in calculating the debtor's current monthly income. Well, the gross receipts of a business might be an enormous amount, whereas if you counted the cost of goods sold and the rent of the business location, a much smaller amount would actually be available to a debtor to pay debts, excuse me. And since the Census Bureau, in coming up with the state median income that we compare the debtor's income to, does not count gross business income or gross rental income, we decided to adjust the forms to reflect net amounts there as well. Gross wages are still counted, but net business and rental income.
Let me ask you about median income. We went to the website the other day to find out what the median income was for a family in North Carolina. And we found that it really varied. It depended how large your family was, and frequently, the larger the family, the lower the income. Does the new law take that into account?
Fortunately, yes. What the law provides is that when you're looking at the state median income for a particular family size, you use the number for that size family or a family of fewer members if that fewer member family would have a higher median income. So you never go down in median income because the number of family members rises. And beyond 4 members in a family, there's a statutory numerical addition. So there would always be uniform increases above 4.
Okay, have there been any adjustments in the IRS standards with respect to the housing allowance?
Yeah, that's an important factor. In fact, it's held up to some extent the issuance of our forms for means testing. We were hoping that the IRS might divide its current unit number, one single allowance for all housing expenses, into 2 components. Because for purposes of the means test, debt payment has to be taken out of the IRS allowance. So to the extent that the housing allowance covers mortgage payments, it covers debt payments and should be reduced to that extent. But since there's not a separate allowance by the IRS for the debtors obtaining the housing, as opposed to the expenses of running the household, the taxes, insurance, maintenance, it's hard to know what part of the IRS allowance should be reduced by mortgage payments. That's an ongoing issue in discussion with the IRS, and we're hoping to get a resolution of it soon.
I've heard some people argue that you get both the secured debt deduction and the housing deduction. Have you heard that?
I have heard it, and I have to say that I don't think that that's consistent with the statutory language, since there is an express provision in the very section of the code that gives the IRS deductions the statement that the IRS deductions may not allow any repayment of debt. So to the extent that the IRS deductions do include debt repayment, I think the statutory language requires us to reduce them.
And the form is structured that
Yes.
way, as I understand it.
Yeah, the
correct?
form reflects the Rules Committee's determination that that's the right interpretation
Bill,
of the
do you
statute.
agree with Gene's analysis?
The way I read 707B2, I think that is correct. I hear the argument, contrary argument. I'm sure some of us will see that issue raised.
Okay. Bill, do you think we'll have the necessary information we need by October 17th?
We will have it. It's just right now maybe harder to get than hopefully it will be in the near future. You can go to the Census Bureau website, and through some time-consuming efforts, you can come up with the median income. You can go to the IRS website, and again, with some time, you can get down to the standards and figure all of that out. The United States Trustee Executive Office website will have those numbers, and I'm sure in the near future, all of our courts, our clerk's offices, and our websites will have those numbers for each location as well. So it should get easier very quickly.
You know, I mentioned last time that I was very concerned about the notice requirements of 342, particularly the 342G says if the notice that's sent out to the creditor is sent to the wrong address, then the notice is not effective. Under 342C2A, it's virtually impossible, it seems to me, for a debtor to determine what the correct creditor address is to send that notice. I think the good news, though, is that in Chapter 7 and 13 cases, the debtor really doesn't send many notices at all. It's the clerk's office that sends the notice. And I assume because the clerk sends the notice, then the clerk is not bound by 342C2A. What do you think, Gene?
Well, I think we've got another plain meaning versus congressional intent issue here. If the intent was to protect the creditor who didn't get notice at their preferred location, then a court might well say, even though it was the court that sent out the notice of the case filing, generating the information about the automatic stay, the court was using information provided by the debtor on the creditor matrix. And so the debtor, albeit indirectly, has provided that notice. If that position is taken, well, then the limitation that you want to take advantage of would not be available.
Except that 342 also provides a way for creditors to give notice to the court at an address that they want to receive their notices, and that might be different than the one that the debtor has to give them the notice at. But
that's an argument as well.
And the reality is, for example, in a Chapter 13 case, a particular creditor might have 2 or 3 or 4 notices because their notice to the trustee for where they want to receive payments may be completely different from the notice they give a debtor or even give the clerk of the court.
you know, one of the possible solutions here is a new rule that will go into effect on December 1st of 2005, and that's 2002G. And that rule allows a creditor to make an arrangement with a bankruptcy notice provider to get all notices at a specific address in a form that they would be more useful to the creditor. So I think it's probably in the creditor's best interest to utilize 2002G. It was certainly going to be in the court's best interest and everybody else's if they do. So to the extent that we can encourage creditors to do that, that's probably something we should do. Now, the automatic stay is obviously one of the most important protections that a debtor has, both for the debtor and for the assets of the state. There have been many changes regarding the stay. Bill and Gene, what do you think some of the most important ones are?
There really have been a number of changes, all the way from some situations where the stay may not take effect or may not come into play, or where the stay gets terminated automatically very quickly. If we start at Section 362B, there's now 10 new exceptions from the automatic stay, and some of the other existing ones have been amended. For example, 362B2, the domestic support, has been expanded and now permits, for example, taking the debtor's professional license or driver's license, which certainly can interfere, Gene, with a Chapter 13 plan, correct?
It could be devastating to a 13 plan. If the debtor's wages are being deducted, the debtor won't have the funds available for the plan. If the debtor's driver's license or professional license is being suspended, how can the debtor get to work or perform the debtor's profession? So those are big problems. And as far as I can see, the only option for a debtor who can't get voluntary cooperation from the state agency that's engaged in these collection efforts is going to be to seek a 105 injunction from the court requiring that agency to release the license or stop the wage deduction.
That's probably true. In fact, I think one of the litigation areas we're going to see, or procedural questions courts are going to face, is when the debtor is trying to get the stay back into effect or keep it in effect past one of these deadlines. What's it going to take to do that? Is it going to take simply a motion, or is it going to take an adversary proceeding and a TRO kind of proceeding?
And one other problem, if we're dealing with the state agency, is whether sovereign immunity applies.
Correct. Another big exception, Tom, that comes into play in consumer cases, or will, is the new 362B 19, which accepts the continued withholding of a repayment on a retirement type loan.
That sounds like that may be an advantage to the debtor.
I think it is, because prior to this, the debtor, for example, in Chapter 13, and by the way, this exception runs across and is consistent with, in Chapter 13 now, the debtor can't propose a plan that proposes to modify repayment terms of one of these retirement loans, and these types of loans are accepted from discharge. But previously, we all considered, or most of us considered, those types of loan repayments to be part of disposable income. Mm-hmm. And so we would say to the 13 debtor, I'm sorry, but you've got to stopped paying that loan, and the debtor therefore faced a tax penalty for an early withdrawal. Many debtors did. Now, since it's non-dischargeable, it can't be adjusted, it can't be changed, there's an exception from the stay. That's a benefit to the debtor in many respects, as well as, of course, to that creditor. Section 362B20 allows the enforcement of liens and security interest following the entry of an in-rem order.
And we've had a lot of those.
Yes, this is interesting because some of us would enter in-rem orders, some of us would enter them both as to real estate and to personal property, cars, for example, where there were multiple filings or other egregious acts. Now an argument may be made that the statute now specifically provides for in-rem relief, but it's limited to real estate loans. And consequently, can I still enter an in-rem order on personalty? Perhaps that argument will be made that I cannot. But moreover, there are tight restrictions on this type of order. It must be an order that's entered after the court makes a finding that this subsequent filing of bankruptcy is part of a scheme to hinder, delay, or defraud creditors. And the debtor might come in and try to get relief from that in-rem order. But moreover, the creditor who gets an order from me saying that must record it in the appropriate state recording office, and it's then effective for 2 years. So in other words, it prevents further filings as to that property, potentially. Section 362B21 is also interesting. It says there's no stay if the debtor is ineligible as a debtor.
How do you know?
Well, that's what's interesting about that, because Section 109G, the eligibility kind of provision, was not amended. And so I was accustomed, like other judges, to making the determination of eligibility after the debtor files. Consequently, if a creditor is saying that debtor is ineligible to file either over the debt limits or filed after a court entered an order saying you can't file again, things like that, the creditor relies upon that and executes upon property because there's no stay in effect, and then I ultimately say as a judge, nope, the debtor was eligible. What does that creditor do? Well, there is a protection for the creditor in the damage provision, which is now 362K instead of H, that says if the creditor in good faith relied upon that belief, you can only get actual damages, never punitive damages. But I think what it really says to the debtor's got to really be aware if there's such a creditor, the debtor's going to have to come in probably with some injunctive relief seeking to get the stay into effect in that kind of situation.
Well, the debtor's also going to have to be careful that the matter doesn't get decided in a state court. You can easily see a situation where a creditor claims that a debtor is ineligible and so goes ahead with the foreclosure without getting relief from the automatic stay.
Yeah.
The debtor tells the state court judge, you can't do this, I filed in bankruptcy. And the creditor says to the state court judge, well, I have an exception from the automatic stay right here. And I'm telling you this debtor's ineligible. If the state court rules on that matter, even if it's wrong,
You're back.
it could be argued that under Rooker-Feldman, that's a determination of the state court binding on the federal court. Now, I personally don't agree with that, but there's a split in the cases, and so a debtor in that situation might be well advised to run to the bankruptcy court before the state court makes a ruling.
Absolutely. The debtor's got to be more cautious here. And let me just mention there are 2 new exceptions that benefit landlords, but they're really rather convoluted. They may have very limited application. For example, if the landlord has obtained a pre-bankruptcy judgment for possession, then the stay will terminate in 30 days, and the debtor has to come in his or her petition and say there's such a judgment and post the cure with the clerk of the court. The problem is that most states apparently do not have any law that permits the cure of such an underrearage on the lease after a judgment has been taken. So we'll have to see if that really has any effect.
Okay, what about repeat filers?
Repeat filers do face a whole new problem because under Section 362C, if the debtor has had a case pending, one case, let's start with, in the prior year, and that case was dismissed. Now, you have to assume it was not dismissed under 707B. It specifically says if I file a 7 and it's dismissed under 707B, I can then file a 13. It's what it's really driving toward. But it was dismissed for some other reason in the prior year. Then the automatic stay is going to terminate in 30 days. If I've had 2 cases pending in the prior year, both of them dismissed, or more than 2, then the stay in the next case never comes into play. Mm-hmm. The debtor can come in and try to put it into play, and the trustee could, but in all those instances, the burden of proof on the moving party to keep the stay in effect or put it into effect is clear and convincing evidence of what, Gene?
of the good faith of the debtor in filing the case. What does the trustee care if the debtor filed in good faith? The trustee cares about whether there's equity in this property that could be administered for the benefit of the creditors.
That's right, but the statute doesn't mention equity or value in the property. It just is tied to the good faith of the debtor as to the creditor you're trying to stay. Not in general, but as to that creditor.
Well, Gene, last time we talked about the problems that may come from the automatic dismissal of a case for failure to file certain things. Do you have a solution to that problem?
Yeah, we have a solution there too. First, let me tell you where the real problem lies. We're talking about 521A1, which lists a series of things that need to be filed right away at the start of the case. Now, most of those are very familiar to us. Schedules, statement of financial affairs. Now, there's some additional requirements. The debtor's attorney has to certify that required warnings have been given to the debtor. But all of these things we're used to. There's this typical 15-day limit under the rules, and if the debtor hasn't complied, there'll usually be a motion to dismiss, and the debtor will have an opportunity to respond to that well before this automatic dismissal in 45 days. So not a big problem. But there is a big problem with another one of the sets of materials to be filed at the outset of the case, and that is all payment advices, wage stubs, if you will, that the debtors received in the 60 days before filing. That requirement of 521A1 is not something you can just look at and see if the debtors complied. You have to know for whom the debtor worked. The debtor may have part-time employment that wasn't reflected in the schedules. You have to know how the debtor was paid, weekly, bi-weekly, monthly, to know how many payment advices might have been received in the 60 days before the bankruptcy. So these are problematic. You can't simply tell by looking. It may be that no motion would be brought in the 15 days.
Well, suppose the debtor's payment is in a direct deposit and the debtor has no payment advices.
Well, another good question. Then you could argue about what's a payment advice.
So what's your solution?
The solution is simple, and the URL, again, is on the screen. We have a provision here that only applies unless otherwise ordered by the court. And what we've done in the Northern District of Illinois is adopt a standing order that these payment advices not be filed with the court. Instead, we've directed that they be supplied to the trustee 7 days before the 341 meeting, together with the tax return or transcript of tax return that's otherwise provided in the statute. This complies with the intent of the statute to have this material available for examining the debtor, but avoids all of the problems that come with automatic dismissal.
Gene, I sure hope you're going to put all your standing orders up there on the FJC website.
Oh, if we come up with any other ones, we'll do it.
Well, Gene, mentioning tax returns, many people think the debtor has to file with the clerk pre-bankruptcy tax returns.
No.
Is that correct?
That is not. The tax return most recently filed by the debtor is required to be provided to the trustee 7 days before the 341 meeting, or a transcript thereof.
Now, wait a minute. A creditor can get that, though, as well.
A creditor can ask for it and receive it directly, but it's not filed with the court. And the non-filing with the court is important because filing with the court presents problems of access by non-parties, the need to protect the privacy of the debtor. Transcripts are better to be given to anyone, but avoiding the filing is important. Now, the problem comes that any party in interest can request the debtor to file with the court either tax return copies or transcripts of tax returns for everything that's filed with the taxing authority while the case is pending.
Now, what's the privacy protection here? Are there going to be any AO guidelines?
That is what the statute provides. The AO is supposed to issue regulations to protect the privacy of this information that's filed pursuant to request of a party in interest. And those regulations are to be effective as of the October 17 effective date. And they're to restrict access to the documents to people who are parties in interest, I believe, and also protect privacy. Now, we have a host of privacy protection mechanisms already in place, but here's an area where the debtors would be very wise to take advantage of the opportunity of filing a transcript rather than the tax return itself. And interestingly enough, the statute does not require an official transcript of the IRS. Any transcript is potentially acceptable.
Mm-hmm. Last time we mentioned there's a change to 107 and the and privacy change. There's also a change to 1112, I believe, dealing with minors.
Yes, and the idea is that a minor's name would not be disclosed in any of the filings in the case.
Would that apply if the debtor was the minor?
I don't think it possibly could. be very hard to honor the automatic stay if you didn't know who the debtor was.
And there's also a rule that's being sent out for publication. It's Rule 9037, and the purpose of that rule is to implement the E-Government Act. And it's not a rule yet, but it's out for publication and will impact on the privacy concerns. Bill, what about professional fees? Any changes there?
There are some changes. For example, Section 330A3 has been amended to say that the court specifically may consider whether the attorney was board certified or otherwise had expertise and experience in bankruptcy. I'm not sure whether that's a real addition. I mean, we could have considered that before, I assume, but it now specifically may be considered. Now, we may question what all can board certified mean. Obviously, there are national boards, there may be state boards, there might even be, I guess, local boards, and but that definition is not given to us. And then Section 330A7 directs that a trustee, and I think it must be referring to Chapter 7 trustee, and I say that because another amendment to 330A3 specifically says Chapter 11 trustee, examiner, specifically, that their compensation will look at various factors, including
Just
their
like other
time.
professionals.
Right.
Yeah,
But-
time and hours.
But I think for Chapter 7 trustees, what the amendment is really saying is that their compensation must be calculated on the commission basis rather than their time.
Yeah, 326 becomes a commission rather than a cap.
I think that's exactly right.
Do you think that board certification is going to make any difference, Gene?
I do not. I think it's going to make a great deal of difference because, as Bill was saying, we always looked at the market rate that the attorney could charge in coming up with a lodestar, and that market rate's going to be influenced by the perception of that attorney's quality, which reflects the board certification. So I think we're dealing with the same thing we dealt with before.
Okay, before we conclude our program, Gene, do you have any comments you'd like to make?
Let me just give an exhortation. We're in a remarkable period of time right now where the bankruptcy law is in flux, and the extent to which bankruptcy can continue to provide a real service to all the parties who are affected is going to depend on the way that we interpret this. We're also dealing with the integrity of the judicial system and doing what Congress has asked us to do. So it's a challenge, but I think we'll be up to it.
Bill, you up to the
I
challenge?
agree with that, and to help with the challenge, I would encourage people to look at those two symposium issues that the American Bankruptcy Law Journal, because it's a wonderful collection of articles, including Gene's article on the means test.
And your article on
and
discharge and
but I'll
discharge
discount mine as being wonderful, but otherwise it's a wonderful collection of articles that I think will be a resource, not just now, but for years to come.
Well, I agree with that, and thank you for doing those articles, and thank you for being here with us today to share your expertise. That will conclude our program on the consumer aspects of the Reform Act of 2005. Thanks again, Gene and Bill, for being with us. The Federal Judicial Center has also produced a program on business bankruptcies, and I hope you will watch that program. They'll be working on one final program in this series that will come after the law is effective and after we've had an opportunity to deal with some of the peculiarities of that law. Please remember to fill out your evaluation forms. They're very helpful to the Federal Judicial Center, and they'll be invaluable to us as we develop the final program. Thank you again for watching, and good luck to everyone in dealing with the new law effective October 17th.